on Energy, and now it's LWE. We've had 5 different companies here in 2 years. That seems a little unusual to me.
I think the trooper was.
Well, I've got a few more things I just wanted to talk about. And I've got one other question. Maybe Seth could answer this one. I'm just wondering on the legality of the host community agreement, because the board never voted on sending that to Energy for approval. So wouldn't that open us up for liability? The board doesn't have to vote on sending that to Energy for approval for the host community agreement?
I'm not sure I understand the question. The board can, the board is considering a proposed agreement.
Yeah.
It's been had negotiation back and forth, and if the board votes to approve it, then that is in itself conditioned upon the approval of Energy.
But the contract was sent to them for final approval after all the negotiating, and the board never even voted on sending it to them. That's my question. Doesn't that open us up for liability because the board never voted on it?
No, I don't. I'm still not sure I understand that question because it doesn't.
Well, anytime you do anything, the whole board has to vote on it. It was never voted on. The host community agreement was never voted on that, hey, let's send this to Energy for final approval.
No, it's been in the process of, legally speaking, it's in the process of a negotiations relating to a proposed contract.
Mm-hmm.
And it's been handled by a subset of the board with the legal counsel.
Mm-hmm.
And it has no legal effect until there is a vote of the full board.
Mm-hmm. Well, I'm just talking, when I refer to that, I'm talking about just policies and the way it's supposed to be done. So that's what I was referring to.
No.
If that could open us up for a challenge because it wasn't...
No, there's no procedural irregularity or any defect in this regard.
And my last question is, the designated haul routes, as far as I know, that's still tentative? Is that tentative still, the designated haul routes?
It's a preliminary, but it will actually come to the town board for approval. And that's what we have in the
For any changes.
So it's still tentative, so if you pass this road use agreement, they could still tentatively come back and change the designated haul routes, is that correct?
They're gonna come to us for approval.
Uh-huh, okay.
As far as a friendly neighbor agreement, I think to clear that, make it simple, if anyone doesn't understand that concept, even legally, whatever's written in the contract, whoever's getting that good neighbor agreement, they must read it over. If they're smart, maybe they'll have their lawyer look at it. And then if they agree to it, then it's not an illegal thing to do.
No, I never said it was illegal. I'm saying that it's opening up the town for liability, and this is according to, from what I read from Judge Costello. I don't know if anybody else read what he put on the site, but the town is liable. And I believe these people should have had to have come to the town for waivers to get out of the host community, or the good neighbor agreement.
There's 2 things. I drafted the good neighbor agreement. The town's not liable for it. The law actually allows these setback waivers and sound waivers to be obtained. That's part 1. Part 2, Emily and Cindy made sure it was negotiated in the agreement. If there is any kind of third-party lawsuit, the company will indemnify you and cover the loss, even if there was a lawsuit brought by somebody that has a good neighbor agreement. It's section 13(2)A.
And what if somebody else takes your company over?
The
Company
agreement
to
is
be-
binding.
Yeah, it has to be binding.
No, the agreement's fine on any successor. And I can speak on the town's behalf regarding the question about the good neighbor agreements.
Mhm.
I've read the decision and recommendations of the hearing examiners,
Mhm.
of whom one is Judge Costello. I'm not sure I understand the point you're trying to make on it, but the point of how it works, essentially, the town setbacks and the restrictions both of the town and of the Article 10 certificate by the siting board, it puts limits, and some of those limits relate to numbers of feet from a boundary or a 1.1 times or 1.5 times, 1.1 times the top neighbor agreement can do is it basically takes a landowner who says, you know what? I have the right under the law and under the Article 10 certificate to not have any tower closer than this distance from my property line. However, if I choose to enter into an agreement with the wind company, saying that my property becomes part of their project area, basically, then that setback, it's not an absolute setback, it's a setback that they can waive by bringing their property into the project. So that's, no one can force a landowner to do that.
Right.
And I believe there are several towers that have been canceled from the proposal during the process because under the town standards of setbacks and the Article 10 standards, the DPS, Department of Public Service has required. Barron Winds couldn't get the agreements they wanted. So if they can't, if the landowner won't agree to waive that or to join in the project, then they can't put it there. That's just sort of the legal.
I'm just concerned about liability issues. For example, our wind law, we're not even in, I guess I would say compliance, but when you look at what the Department of Health wrote, that's better than what's in our wind law. The town should be adopting what the Department of Health recommended for the decibel level for the turbines. Does that open us up for liability right there? I mean, it seems to me an attorney could come in and say, here's what the Department of Health wrote, and you guys aren't even following their guidelines.
Well, the town's wind law has been upheld in part, well, the wind law has been upheld by the siting board.
The siting board's all pro-wind. That's nonsense. I mean, you know, everybody knows that. Come on.
And I won't dispute the siting board's motivations or ideas, but the law of the state of New York, which we all have to follow, and I have responsibility to interpret for the town, specifies that the siting board has the authority to determine what are the standards under which that any applied for project will be built. And they, on September 12th, issued a decision which is binding on the town. It's also binding on the wind company. And it has identified provisions of the town law that will remain in full force and effect. And it's identified other provisions of the town law which don't become nullified, but which may not apply to this specific project. Not that we anticipate any other projects happening in town. So the siting board doesn't negate the town law, but it can give exceptions and basically the ability for the wind company on certain specific provisions, and there are several of those. The most notable of which is the work hours, which the siting board determined. Town law says they can't work on Saturdays. Siting board says all the other towns say they can work on Saturdays. It wouldn't reduce the total number of days of any construction activity. So the siting board said that provision can't be enforced against the wind company. But there's others, like the well testing. Siting board says that applies, and almost all the other provisions of the town law continue to apply.
So I guess my question is, if they go for a waiver for the wells and they get ruled in their favor, is the town of Fremont going to pay to have people's wells tested? If not, then you should put some type of language in there saying, based on, you know, if they apply for a waiver, then the town should be getting more money to test for these wells.
And the town has the right to participate in any application or appeal of the decision that
I'm surprised.
the Barron Winds
I thought
might
you were
make.
pretty intelligent.
Um,
You obviously have
I don't
looked at
see
the
any
other side of the
scenario
fence.
or legal basis on which the town would incur any liability.
All you're
Because
thinking
the
about
town
is
isn't building a wind project.
That's right, but the number one, I've said it 100 times, their fiduciary responsibility is to protect the people, and that includes the wells.
If we can add something to the well study, the issue has been addressed by Department of Public Service, the Department of Health, and it was adjudicated. Did we win on this case? No. In Casadega, yes, there's a standard that the agencies ask the applicant to meet, and it's not 3,500 feet. The Department of Health had testimony, the Department of Public Service had testimony in there that said, and so did the applicant, this is what could happen if there is an impact, and we will address that. So there's no, what even your expert said is that there's no scientific basis to go to 3,500 feet. That was the reason for why we sought the waiver. He's the engineer. I'm not an engineer, I'm an attorney.
I don't know if Hunt Engineering could even speak on the town's behalf on that, because from the evidentiary hearing, from what I recall, you guys didn't have any expert witnesses in regards to wells, and neither did we, yet we had all this money there in intervenor funds, and we never even got an expert witness to testify on our behalf. So you might have expert witnesses in Casadega or whatever, but it wasn't done here in the town of Fremont.
The town engineer testified that there's no scientific basis for 3,500 feet.
No, I don't believe the town board ever authorized him to say that, because I've never heard him speak at any of the meetings about the wells, because I would have brought it up, but he never comes to the meetings, so.
Well, and a part of what everyone has to keep in mind is testimony has to be given based on individuals' own understanding and opinion. Town board hires some experts, and they testified to the truth, and most of that fit with what the town was seeking to support. But at the end of the day, they had to testify to their honest opinion.
But nobody testified on well testing. There was no expert witnesses on well testing, period.
Not that I'm aware of.
So I've got a question. Let's say they apply for a waiver, and then the town has a chance to respond to that. Do they bring in witnesses then, or it's just a written response from you? How does that work?
It depends how far it goes.
Okay.
And that would be a matter of legal strategy in terms of consultation with the board.
Okay,
Which would be privileged.
all right.
It isn't all addressed in Article 10,
Yes.
pretty much?
Yes.
Yeah, that's the way I look at it. It was all addressed in Article 10. When you agreed to that, that was it.
No, what we're saying is they're willing to try to change it now.
Yeah.
But the study board's
So
decision
the company
is-
is trying to change it.
is the standard. As they've noted, it can be changed, the study board has to have a good basis, and the presumption is what they decide will stand, unless powerful evidence is brought to the change.
Justin, if you do appeal one of the recommendations, for example, like the wells, what's the filing deadline, or when's the decision made on appeals?
On whether we appeal or not?
Yeah.
No, you're asking, when's the decision come down?
Or, when would you do it, or when does the decision come down?
It has to be done, the idea, the appeal itself would have to be done very soon, in a week or so. And then the decision is in 60 or so days, 60 or 90 days.
Why don't you guys just wait till next month then and see if they file the appeal? It's pretty simple.
So,
I'm not sure what, the well testing is controlled by the Article 10 process.
You wait till next month, then it's too late for you guys to file for a waiver, correct? Isn't that what you just said? I said there was a deadline.
What's the relevance?
The relevance is that there will be,
Protection.
that there'll be protection for the wells.
There is protection for the well.
Well, according to you, that's,
I'm not, no, not according to me, it's according to the experts, so I'm not an expert.
like I said, we didn't have an expert well here in Fremont, so.
Representatives.
Is there any other challenges to the siting commission ruling by bear and winds that's gonna be filed in the next week or so?
I don't understand what you mean. Are there any other issues with the decision?
Exactly, yes.
I don't know.
Yeah, we don't know. There's, of course, things in there that we don't like, but we have to kind of weigh as to whether or not those are worth bringing to the siting board.
So
So,
maybe we should wait until next month till all the dust settles and see what
Yeah.
you challenge them on before we go forward with the
It's
host
sort of like
hearing.
saying that's a quid pro quo, and this is not a quid pro quo. What we're looking for is the town of Fremont we wanna know that we're gonna be working together. It's not perfect,
So do we.
Yeah, but you're not giving
In the
us
next week or
concrete
so, you could
information to
challenge
make
it
our
in so many
basis on.
ways.
So these two agreements, one has to do with roads, one has to do with community benefit. Neither has to do with well testing, that is controlled by the state, so it is a
Then why
separate
did you
item.
tell us that it was supposed to be, no, I'm not addressing you, Justin, I'm addressing the board. When we brought up the wells from day one, you guys have been saying, oh, that's gonna be in the host community agreement, that's gonna be in the host community agreement, that's gonna, you know,
We put it in the law,
it's in the local law?
yes.
That's why it was identified by the siting board as a requirement condition for the certificate.
And then it went to
Because it's in the
35,
town
and that's
law.
what they're trying to get a waiver on?
Yes.
Okay.
Well, that we don't know. There might be, he didn't say yes or no. There could be waivers on other issues. That's why you should wait another month till the deadline has passed
There's
and
no
then
other
pass it.
waivers for the town of Fremont that we're seeking.
Are there
Well, that's not what you didn't say that a minute ago. You were kind of beating around the bush there.
No, you didn't, you asked Baron Winds, you didn't say Fremont. So
Oh.
the town of Fremont,
Any waivers to our local law?
well, if you look at it, the only one that was, we already have construction hours. The other issue was the wells.
Not really, that's what we're talking about.
And that's all you are
We have,
possibly
I mean,
looking
We haven't decided yet, but either way, these are things that are controlled by
the state.
the state, not in the road use or the host community.
I don't know why the town didn't even put something in there. If the hours they're working was so insignificant, then why did we even have it in the law? Because I know my road's gonna be a designated haul route and it's gonna be hell on earth, I'm sure, with all the traffic going up through there.
Doesn't mean the town agrees with the decision of the siting board, but that was determination of the siting board.
Well, then you could have filed in a waiver and said, we disagree and these are the reasons why. A lot of these board members aren't gonna be affected by designated haul routes with all the construction and all the traffic and all the dust and,
A lot of people in this room aren't gonna be.
Why don't you move back to Hornell?
here we go with Mr. Phelps again.
I'm the highest taxpayer in the land of Fremont.
She's been in business for 40 years.
Yes.
I think the board should address Mr. Phelps with the swearing and the carrying on, the insulting of people, kicking my camera. I've called the state police on him tonight.
Actually, we
She's
asked him
actually
about the
still
wells, he
waiting.
told us
Oh.
to F us on.
No, I didn't realize she was waiting. Oh,
Okay.
sorry about that. I thought you were up there waiting.
Running your own mouth. So you guys just have until a short period of time coming up.
That's right,
to
but
do
still,
any
the
kind of
items
appeal.
that he just brought up are not related to the host community agreement
Right.
or the
but-
road use agreement.
But what you were talking to us about and all that.
Yes.
To try to get an appeal on that has to be put in by a certain date.
Yeah.
And then after that.
Somebody
if you guys don't
else,
do
somebody
it-
else could file an appeal,
That's true.
and then if they file an appeal, then we have a chance to respond and add other things to that as well.
What do you mean if someone else
So-
appeals?
So if the town of Fremont, for instance, filed an appeal to the town as a party to the Article 10, the town could file an appeal to the decision relating to the work hours. But that would open it up for
Yeah.
the
So it's hard.
parents to respond and have further motions and arguments
But
and
is that
briefs.
the time limit when anybody can do this?
30
whatever
days
it is?
from the decision. I think it may be a few days later because of weekend holiday.
Yeah, correct. If we're all under the same,
It's the same limitation for all parties.
Okay, so let's review the road use resolution. Seth, would you like to read that?
So the proposed resolution is resolution of the town board of the town of Fremont for approval of a road use and repair agreement with Baron Winds LLC in connection with a certain wind energy project. Whereas Baron Winds LLC, Baron Winds, submitted to the New York State Board an electric generation, siting, and the environment, siting board, an application for a certificate of environmental compatibility and public need pursuant to Article 10, the certificate, to construct a wind energy facility, portions of which will be located in the town of Fremont, the wind project. And whereas the siting board issued a decision on September 12th, 2019, to award a certificate to Baron Winds to construct the wind project with certain restrictions and conditions. And whereas the town of Fremont has participated